And just like that, things start off serious, with a firm warning. If you show even the smallest trace of alcohol in your system, this judge isn't giving you a second chance. You go straight to jail. No excuses, no arguments. Watch how the II judge lays it out clearly. She's not tied to what probation recommends. That's a big deal. Even if someone suggests going easy, she has the power to give the full sentence. Then comes the numbers talk. In these cases, every decimal matters. It's not just math. It's the difference between a fine
I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Sorry.
And that's all.
and time behind bars. Did you hear that part? The man on trial compared his test result to an AI chatbot making a mistake. Creative? Sure. But that's not exactly a legal defense you'll find in any courtroom.
Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honestly, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Your Honor, I think it's made. The issue, and it's been brought up with Ms. Anderson, is...
Here's the reality. The legal limit in Wisconsin is 0.08. He allegedly tested nearly 3 times over. No surprise the judge is losing patience. She even gives him a quick lesson on decimal points.
He had a question about the grams per 100 milliliters.
Dude,
And
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only...
Points. It's a little funny, but also serious. The law doesn't care about your math skills if the test proves you were over the limit. Then comes the turning point. He admits to the test results.
beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce of...
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, Mr. Lamprecht, It's 0.08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a 0.221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late. Okay? You're not supposed to be.
He admits to driving. Once that's said out loud in court, the case is basically closed. And here's something important. This isn't his first time. It's his 3rd offense. That's
work, okay? You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating
I'm just
science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a 10th. 2 numerals behind the decimal is a 100th.
Yep.
3 numerals behind the decimal is 1,000th.
Yep, I know math.
Okay, and 1,000th is 10 times less than 100.
Well, let's cut that off, okay? You blew a 0.22 with a PBT.
221.
Or 0.221, okay?
Yes.
So let's say you will cut off the 1, because that's what math does. You get to cut off certain things. So you were 0.22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000th is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
No, if there's 3 numerals, because if it was point.
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra 1,000th in the decimal point?
It's not an extra 1,000th, though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yes.
You want to go to trial over that and have the lab analysts explain it? Because I'm going to tell you
why the penalties are much tougher, even though no crash happened. The prosecutor's request makes sense too. They're asking for an ignition lock and tight monitoring. It's not just about punishment.
Are smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask your questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then so give me the knowledge because I like math. And
here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to
hours.
piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail. Get out. I got a job.
All right. So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And do you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right. Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines?
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily?
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap.
It's to stop him from making excuses the next time he's tempted to drink and drive, but then interrupting the judge.
Crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate time, okay? This isn't a time to conversate.
Okay.
This is a plea and sentencing in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right. Because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keene, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right. Okay. You have any? No. All right. So based on this, the OWI third, count 1, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP, but he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked in a release, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on a third offense, which I believe is $1,911 for fines and costs. It's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keene.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service.
Not smart. Talking over a judge is one of the quickest ways to get more time added to your sentence. Here's the strict part. Even the tiniest trace of alcohol, just 0.0.
Deal with the harm to community, although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also, as with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means, I'd be careful about even non-alcohol alcohol, because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system, because OWI 3 is the last one. It's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement because, a pain, but Mr. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing.
ZOA 1 is considered a violation. Just one bite of something with alcohol, and you could be back behind bars. Finally, the judge shuts the door.
And there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI 3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the, less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
No, nothing that I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is, again, serious. You're putting yourself at risk. You're putting others at risk. The fact that you blew a .221 had blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for interrupting.
Don't interrupt me again. You interrupt me again and I will hold you in contempt. I will hold you in contempt and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Okay.
I need to ensure that the public is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again. What I will do is I will follow the IDIP guidelines despite all of the issues.
She refuses to waive the fines. She wants the consequences to be clear. This is about accountability and making sure the lesson sticks.
Case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. If you wish to convert the 75 hours to additional jail time, you can do so. Talk to Ms. Anderson. She will ensure that the court gets a letter and you must pay for every, it's an additional 8 hours of community service for 1 day of jail time. So it's an additional $18 a day that you would need to pay if you wish to convert any community service to additional jail time. You must report immediately report to jail. And that means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You don't get additional time. This is where I'm very serious. You blow even a 0.00000001 with anything with alcohol, 0.00001, that's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail, and you will sit the whole sentence. No good time, no Huber. I do not take, I was near rubbing alcohol. I do not take, I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Okay, I take no excuse. It is an immediate report, no good time, no Huber. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, a civil judgment will be entered against you. You will also need to, you could sit up to 6 months in jail for that. I make sure that the money is paid. If it's not paid, it may result in an additional 6 months of incarceration. So ensure that you make your payments. When are you going to pay off the entire $1,921?
I have enough for the monitoring and the jail fee at this time.
$150 a month you must start paying. I'll give you August 1st. I'll give you a little stay until August 1st, but then in August, you must make your first payment at $150 a month until that in full. Again, if you miss one payment, a warrant will be issued. You could sit up to 6 months in jail. It's very important that you make sure you pay. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Report to jail immediately. Your DNA is ordered. They will take that. You can request it be expunged through a written letter to the Department of Justice. Mr. Renicky, what am I missing?
I think you've covered it. Thank you.
Mr. Keene.
You aren't not on that, but I did have a couple of items. One is, and which didn't get filled out, if he has the opportunity while he's sitting to fill out the petition for half-price ignition air lock, if he qualifies, can he submit that to the court?
He can. I'm not going to give him time to do it. He's going to go report to jail.
Right. Understood that. Understand. And then the other item is one I filed way back in October, and you at the time rejected the proposed order and what, and so could you
to waive fines and fees?
Well, it's to reduce the fees by the amount paid for the IDI, the alcohol assessment and the driver safety plan if they're provided to the court. And the 10th Judicial District, I will admit it varies by court. Like Douglas County does it, Barron has it.
Want me to waive?
What it would be is like he has that fine of 1,900 and some bucks. What the statute allows is, if the court grants it, is to have the amount of the fine reduced by Mr. Lampick providing receipts to the court for the assessment and driver safety fund.
No,
okay.
I don't do that. And so you can understand there's not much that can be waived. There's a lot of mandatory surcharges in there. And when you go through it, really, because I've had really poor people that have asked, can I just do community service with the ones that cannot be waived? There's not really that many that can be waived. And plus, this is a punishment. That's part of the punishment. And so I see it as a punishment. And that's why the legislature has increased, and they continue to increase these fines and fees. It's to say, don't do it again. Don't do it again. Don't do it again. And so, no, I'm denying that motion.
Yes, sir.
Thank you. Ms. Atkinson. Ensure that he gets and reports to jail immediately. You may.
Can I make a couple phone calls?
That's up to the jail.
Yeah.
Today's ruling was a game changer. No excuses accepted. What do you think? Share your thoughts in the comments, hit the like button, and subscribe for more real courtroom moments. See you in the next one.